Another special edition of Huddle. I am your host and your friendly neighborhood real estate broker, Mike Fondario. And if you weren't here last time, you may be surprised to know that we did spend an entire hour reviewing the REPC. We did make it through section one, all the way through section one. But to be fair, there are 4 sections in section one. So we're going to continue on with section 2, and no stone left unturned. And, there's a lot of experience on this phone call. So if you do feel the need to contribute and give some background to any of the things that we're talking about, please do. Because after, a few minutes, I do get sick of hearing myself talk. So any contributions is definitely welcome. And please do it. Please do it. So as I said last time, we got through section 1 and we were just about to start on section 2. So without further delay, let's jump right in. All right, y'all, you should see our wonderful REPC on your screen. Section 2, purchase price, payment of purchase price, 2.1. Payment of purchase price. So the purchase price for this property is X, except as provided in this section. The purchase price shall be paid as provided in section 2.1A through 2.1E below. Any amounts shown in section 2.1C and 2.1E may be adjusted as deemed necessary by buyer and the lender. So I think everybody kind of knows what some of their pet peeves are for this section as we talk about specifically. Let's just talk about a few of them. My biggest pet peeve is seeing TBD or blank on specifically 2.1C, new loan. So how many people in here feel that it is, morally accept? No, that's a bridge too far. How many people feel it's even a possibility of being acceptable to have 2.1C empty? Are there circumstances in which 2.1C should be empty? Yeah, I mean, if you're paying cash, it should be empty, right? Now, if you well, let's take it from, because there's always 2 perspectives of this. If you are a listing agent and you receive this offer, you receive an offer, and you are definitely aware that they are getting a loan because they sent, they sent some stuff from the lender letting you know that they actually talked to a lender. So they're getting a loan, and 2.1C, there's nothing there. Should you be concerned at all? Is that something that should, is that something that you should dedicate some time and attention to? What is your strategy? Throw it in the chat. Tell me what your strategy is if 2.1C is empty. Do you leave it blank? Do you just move about your business? Do you just make a phone call, see what's up? What are you going to do there? Seems like an important bit of information. Lisa says, yes, because they might have a property to sell they are not disclosing. Remember, well, that's a good point. You're saying if it's empty, it's a concern because they might have a property to sell that they're not disclosing. Yeah. But remember, in 2.1, that opening paragraph, it says any amounts shown in section 2.1C and 2.1E may be adjusted as deemed necessary by buyer and the lender. So they can adjust those at any time. So it's not set in stone. Bob says, send the REPC back and tell them to put a number in the REPC. Okay, that's also an option. I think the bottom line here is that there is a reason why there is A through E and then it ends in a purchase price on this purchase contract. So we all have it in our nature to wonder about the buyer's ability to buy your listing. And we should be insanely curious about how are you going to pull this off. And part of that is there's got to be some accounting, some explanation of where the money's coming from and how you're going to obtain it. So let's paint the problem in extremes to kind of show us where we're going. If they're getting an FHA loan, for instance, and the requirements, the cash requirements for an FHA loan are not the same as they are for a conventional loan. We kind of all know this. But if they show earnest money of $1,000 and then they're getting the max they can possibly get on an FHA loan, that's pretty valuable information, right? It says something about their financial condition. And so it may motivate us to ask additional questions about, can they really pull this off? Did they have to scrape together $1,000? Are we going to be concerned about them having, some extra funds at closing? All those things are important. But to just leave it empty because, we don't know what the final number is going to be, that's not an excuse. And if you have somebody who is giving you that reasoning, you need to say there's a very specific reason that the second sentence, maybe it's the third sentence, in 2.1 says that you can change those because you can, and it's not set in stone. But it's your first declaration of what you think is going to happen. And if you have no idea what's going to happen, you may not be ready to purchase this property. So to go to Bob's point, yeah, it's a little bit tricky situation to have. They've already signed this contract and they can't just go back in and fill in 2.1. And it seems it may be awkward for them to generate an additional contract. But I don't know. How would you guys handle it? I think I know how I would handle it, but how would you handle it if you want them to make a declaration in 2.1? Because I kind of think it's important. And it does go to, if people are leaving all of this blank and just writing TBD, it feels too sloppy to me. We're getting paid well to do this job, so we should be thorough, and that's part of being thorough. So how would you handle it? Do you reject this offer? Might be risky for your seller. You can counter it and maybe, say 2.1 shall read as follows, and then kind of do your own accounting of that information there based on a conversation you had. How would you handle it? How have you handled it? Throw it in the chat there if you will. Or just unmute yourself and talk at any time. That would be great too. Anyway, that's a huge pet peeve of mine. Not to mention, when we talk about 2.1C the whole time, let's talk about 2.1E because that should be readily available to them. How much cash do you actually have? Where is this cash coming from? Is it currently residing in a bank? How important is that to this situation? It's really important. It's always really important. And questions should be asked about those. And again, for maybe the third time, those amounts can change. And so many people treat those amounts as, some official declaration, and we can't adjust those. So anyway, as a company, let's not accept the habit of TBDs anywhere in section 2.1. Anybody have any questions about 2.1 at all? A through E. Now, this happens. People do bad math. What if 2.1, they declare the buyers paying $500,000 and then their math adds up to a different amount in purchase price as you make the accounting in further on in that paragraph? What do we do there? Which one is more importanter? I'm going to go ahead and say that 2.1, that first declaration, is always going to be the most important. But you should never let that the total of lines A through E, if that doesn't match your purchase price for the property, always clean that up with an addendum to make sure that there are no additional questions. All right, we've never moved so quickly through a paragraph before. Moving on to 2.2. Sale of buyer's property. For the uninitiated and for the newer agents out there, the sale of buyer's property is relatively new. I think it might be I don't know, 5 years old. Somebody might remember those actual dates that has a good memory. But sale of buyer's property, buyer's ability to purchase property, to obtain a loan referenced in 2.1C above, and or any portion of the cash referenced in section 2.1E is or is not conditioned upon the sale of real estate owned by the buyer. If checked in the affirmative, the terms of the attached subject to sale of buyer's property addendum apply. A lot of stuff going on with this very simple paragraph. The biggest thing I've seen lately is, again, some sloppiness or laziness where they check in the affirmative and then try to find a way around using the buyer's property addendum. There is no way around it. Yeah, there's circumstances that are better suited for, maybe an additional addendum or something, but you're required as a real estate agent to use that addendum. So if you are checking in the affirmative, you need to do the subject to sale of buyer's property addendum without question, because it's telling you that's what happens afterwards. Before this paragraph, so people don't know, because I think the context of this matters a lot, people weren't required to disclose I think they often would, but they weren't required in the REPC to disclose whether or not they had to sell their primary residence in order to qualify for the loan. And I think this is a great change in my opinion, and it's really important because I think a lot of people were abusing that situation and writing offers for property and speaking to their ability to purchase, all while having to also sell their primary residence in order to qualify for this loan. So very important, but it also sets up too, to me, a scenario in which their ability to purchase is front and center and a requirement, regardless of whatever angle they may take to disclose or not disclose this. Oftentimes I do get questions about, not oftentimes, 3 or 4 times a year, I'll get a question that goes something like this. Hey, my buyer is selling their home in order to facilitate the purchase of this property, but they can qualify without it. They have the income or the assets or the this or the that. So do we have to mark that? I think in those situations, the intentionality is what's most important. If their plan is that they are selling real estate in order to purchase this property, then I think the right thing to do here is to pick it is conditioned upon the sale. If they're really deciding between the two, I have the cash, I'd rather not use it, but if I have to, I will. Maybe we don't have to check it because they have options at their disposal, and maybe we don't have to check it in that situation. But be careful with that, because the REPC is literally saying go out of your way to disclose all the important things about your ability to purchase real estate. So don't game the situation at all. Any questions on that? Questions, comments, experience, anybody would like to share? Doug, I just feel like you have a wealth of knowledge to share. So at any time, I highly encourage you to push that unmute button and just say whatever. I don't even care if it's real estate related. I know you've got a lot of stories that are great. So
Is
at
that
any time.
because I was smirking or laughing when you said that?
No, it's a vibe. I
All
know
right.
I know this is all digital, but
Well,
when you're
I
Zoom
don't
has a
have
feature.
my
Yeah.
I don't have my thoughts together on this, but I know I've seen those emails as recently as this morning about the meetings at Metro Title. I think February 18th, related to the source of where cash came from. Um, I don't know if you want to say anything to that. I don't really have any thoughts because I don't quite understand the change that's going to happen, but I don't know. Perhaps
Oh,
there's
well,
that.
yeah, that actually is a good subject to talk about that relates directly to that paragraph, because those FinCEN, FINCEN, those rules are coming into effect March 1st, is my understanding. And everybody should have seen, just like Doug has mentioned, those emails that have gone out announcing those issues. And the reason that Doug doesn't understand it has nothing to do with his ability to read, nor the time he took to read those emails. It has to do with the fact that the people making the rules also have not put out any information about what they're talking about. They just know for a fact that it's March 1st. Everything else is sort of unknown at this point. That's my understanding. And the last I talked to a representative at Metro Title, that was their answer. Like, yeah, these changes are coming. And, the obvious questions that you would follow up with are, well, what kind of documentation do you need? TBD is the answer to that. So no one's behind the eight ball on that. We're all just patiently waiting for all the immense disclosures we're going to have in regards to that. Yeah, coming down the line, folks. I think my advice on that issue is if you have closing coming up, if you have closings coming up with LLCs or trust or any of those things, I think the right thing for you to do to sort of cover your bases is to just make them aware that yes, there is a disclosure coming your way, and no, I don't know the details of it because they haven't disclosed it yet.
And Mike,
Because
I
yeah,
saw a question come about, is this only in cash transactions? Do you know? I don't think it is. I think it's,
no, no, no. The my understanding is the target of of these regulations are really targeting ghost buyers, money laundering, that type of thing, and not necessarily whether or not you're paying cash. And I think they've always had some disclosure in there. For instance, if you have an LLC, of course you have to provide documentation around it and who are members of it. But now, my partial understanding is that, if you are buying through an entity that is owned by other entities, well, you don't just get a stop at the one entity. You got to go till the people and the correct people and are all identified to the final conclusion, so to speak. So I think it's just a lot more disclosure. And yeah, I mean, honestly, from my perspective, I could have missed something. But the last time I talked about this with Metro Title, who are the people who are going to be gathering this information, was they really don't know a lot. And I think they're paying attention to it because they don't want to look like fools. So they don't know a lot, and we don't know a lot, and you just got to be ready. So trust LLCs, any type of entities, just be prepared for additional disclosure than you might otherwise do. So yeah,
Yeah, but
um,
Mike,
yeah,
this whole issue about a trust is a little foggy because, whenever I've bought a house, it's always been a trust, but we've got to take it out of the trust to close, and after it's closed, they put it back into the trust. So is that one that's going to have to,
it's a good
fall under
question.
FinCEN?
I would guess, yeah, I don't think we have
Because
any
technically,
answers
when
for
it's
that.
closing, it's not going to be in the trust.
Yeah, I don't have any answers for that. My guess would be though that there's also like I think if they're being as thorough as they're representing this situation to be, I would guess that you would still disclose it. Um, and particular, I mean, if you as the seller take it out of the trust before you put it under contract, you know, that's a different scenario. But if you do it while it's under contract, yeah, I think you would have to probably disclose. But again,
Well,
that's just
typically the title company is taking it out, an hour before you
yeah,
close, and then they put it back in.
yeah. In those scenarios, I would guess that you're disclosing. You're going to be under those disclosure rules, those additional disclosure rules. And my perspective is if it's just the standard issue trust that everybody's used to protect assets for their family, I would guess that the disclosure wouldn't is not going to be significantly above and beyond what it normally is. But again, I could easily be proven wrong here because I don't know.
Yeah, I
Um,
understand if it's in a trust, it stays in the trust, they close and it's still in the trust, it hasn't been transferred in and out. I understand those would qualify in a big way, but
Yeah. Yeah, that's a good question. I would guess, we got less than a month. I would guess that I would pay close attention to your emails on this issue over the next few weeks, because I would imagine that all those rules are going to come out and we'll have a list of them. Because I don't know how you start gathering information in the way that they're saying they want to gather information without those rules in place. But crazier things have happened. All right, everybody knows what we're talking about here, right? I hope so, because this seems like a really big issue that I don't know about a really big issue, but a significant enough change that you want to be aware of it and not be caught flat-footed when somebody asks about it, or when they call and go, "Why are they asking for this information?" You want to have some perspective there. So anyway, stay on your toes. Stay on your toes. Anybody have any other additional comments on that issue? Great, moving on. All right, man, we cruised through a whole paragraph in under 20 minutes. We're moving. Settlement and closing. Section 3.1, settlement. Settlement shall take place no later than the settlement deadline referenced in section 24D, or as otherwise mutually agreed by buyer and seller in writing. Settlement shall occur only when all of the following have been completed. A, buyer and seller have signed and delivered to each other or to the escrow closing office all documents required by the REPC, by the lender, by the title, insurance, and escrow closing offices, by written escrow instructions, including any split closing instructions if applicable, or by applicable law. And B, any monies required to be paid by buyer or seller under these documents, except for the proceeds of any loan, have been delivered by buyer and seller to the other party or to the escrow closing office in the form of cash, wire transfer, cashier's check, or other form acceptable to the escrow closing offices. This one's, they're all big deals, but this one's definitely a big deal. I feel like, again, 2 or 3 times a year, there's always somebody that's trying to, massage or maneuver this paragraph to fit their needs. And whenever it comes up, it's always a bit of panic. And remember, settlement occurs when everybody's signed and the money is there. Not necessarily the loan money, but people don't get to say, well, I signed, but I don't have my cash. Everything else was taken care of. Well, if you don't have your cash, you didn't settle. You just didn't. If your cash isn't there, you didn't settle. And if your cash is there and you didn't sign all the documents you need to sign, you didn't settle. Bottom line. Okay. So just be aware of that. You got to complete all the steps in order to do that. Now, and we oftentimes, even in common parlance, I'll frequently, mix closing and settlement, even though as a broker, that's kind of embarrassing, but I still do it. Closing and settlement are very different things, and they have different meanings, and we should all be very clear about what those meanings are and why they're different. Closing, for the purposes of the REPC, closing means that A, settlement has been completed, and B, the proceeds of any new loan have been delivered by the lender to seller or to the escrow closing office, and C, the applicable closing documents have been recorded in the office of the county recorder. The actions described in 3.2B and C shall be completed no later than 4 calendar days after acceptance. This is also kind of an interesting perspective to have. That's a lot of time, isn't it? And I have had probably 4 or 5 instances. By the way, this story is a story of people abusing the REPC and of pettiness, and why you should always, no matter what, kill them with kindness, because pettiness can get you in a situation where the seller does not allow the title company to, actually it can occur both ways. Anyway, the title company, by instruction from either party, is given them instruction not to record and because they have 4 days to do it. And that is a mess. It's a massive mess, and people abuse that situation all the time. But it's necessary, especially with loan proceeds and such. And so it gives them 4 days. Ms. Criddleball, can you give us some perspective, if you're actually paying attention? Because I know you're a busy woman, but on the delivering of proceeds, and what do you think is the standard practice for a lender? Are they pre-delivering those proceeds to the title company with instructions, or are they refusing to do so until all the documents have been signed?
On funding day
Yeah,
or settlement?
on funding.
Yeah, we usually send them in the morning and then we give them permission to release once everything's been reviewed and signed. So
Okay.
they do send them off early a lot of times, but they can't be utilized until the closing department has reviewed that everything's taken care of.
Yeah. So they're delivering the money, and then they wait until they get all their stuff until they give permission to release the funds.
Yeah, they're not just saying take it and run with it. They want to make sure everything's signed.
Yeah. Are you aware of any lender that is sort of doing the opposite, waiting till they receive all their signed documents until they wire money to the?
Some lenders do. Yeah, every lender is different. So we have some lenders who would send it out later once they see the documents. So I've seen that happen before, but the majority of lenders will they'll wire it out in the morning, and then they'll release the funds as soon as they see the closing docs.
Okay. Yeah, I feel like I think it's probably pretty rare. Is it rare in your experience that they're not doing that?
Yeah, it's pretty rare.
In that order, yeah.
Mm-hmm.
And I feel like maybe 1 or 2 times I've seen that, but I don't think it's much of an issue anymore. I think it's just too easy to do it the better way. All right, does anybody have any questions about the differences between settlement and closing? So they're kind of a big difference. All right, good to go. Moving on, possession. This one's always great. There's always every year there's always fights over possession. Section 3.3, except as provided in section 6.1A and B, seller shall deliver physical possession of the property to buyer as follows. You have the options of upon recording, or 24 hours, or not blank hours after recording. I put that in there myself. And number of calendar days after recording. Any contracted rental of the property prior to or after closing between buyer and seller shall be by separate written agreement. Seller and buyer shall each be responsible for any insurance coverage each party deems necessary for the property, including any personal belongings, any personal property and belongings. This provision of the section 3.3 shall survive closing. So this, a couple of issues that surround this. We do have a short-term rental agreement addendum that can help address some of these things. But, what is the general consensus of the audience of when you can, how many calendar days you can probably put in there and be safe, as opposed to let's just use the short-term rental agreement addendum to cover the time between closing and possession? What's the feel? What's the vibe on that number? Do you feel comfortable putting 14 days after recording and just running with it? How does that feel? No issues with 14 days?
Well, as long as you got a signed rental agreement with it, even if the rent's $1 or $0.
So Bob is saying that he's totally comfortable with it as long as there's a short-term rental agreement in place. Is that right, Bob?
Yes.
So how many days is it where you feel comfortable without a short-term rental agreement? So 3 calendar days, 5 calendar days?
Well, the last one I did were 4. The people I was representing the seller, and the buyer was a hoarder, and we knew he wasn't going to get all this stuff out. He'd asked for 48 hours. So we gave him the 4 days, and then with no rent due during that time period. But when it came to the 5th day on, it was $1,000 a day. And it got him out.
That's motivating. Yeah, I don't know that there's a magic number there, but I think you should use the circumstances to dictate when you feel it's necessary to convert from just simply checking a box for the number of calendar days after recording and converting that to a short-term rental agreement addendum. Because I think you could make an argument where 4 days is sort of the limit, and you should do it at 5, and you can maybe make an argument that it's 7 days. I think, though, that at 8 days, you should have an automatic, if it's anything over a week, you should have an automatic short-term rental agreement, in my opinion. I mean, I don't know why you would just take the risk. And as Bob pointed out, we don't really have to involve money. The money aspect of it is paying rent or deposits. That's sometimes is the least of our worries. We're really talking about liability here and putting agreements in place that help protect our clients while that transition's occurring. But you could also make a really good argument, and in Bob's case, I think he did a really great job of putting in penalties because he saw a situation in which there's a lot of stuff there to move. They haven't started. We don't trust them. So we're going to put a massive penalty on them if they go over that possession deadline that we put in there. So there's ways to handle it. But if you're thinking for more than a few minutes about whether or not you should use a short-term rental agreement addendum instead of just checking, and putting calendar days, you should do a short-term rental agreement.
Well, the big thing with a short-term rental agreement, it reinforces them to go out and get insurance.
Yes, that's a really good point. And it also, there's a lot of stuff that makes the condition of their, possession of the home much clearer, because Bob's right. Like there's all sorts of issues there that people just sort of take for granted and overlook. And you won't do that with the short-term rental agreement in place. So, don't be afraid to use it. And it's a good doc. Anybody have any questions on that? Any questions on section 3.3?
Hey, Mike, and this maybe is for Bob. I've not had this instance before, but tell me, what are the potential issues with someone else or continuing occupancy? So, in other words, what we're talking about when it comes to insurance, and let's say that my client ends up staying in the home that I'm selling, and it's now insured by the new buyer, and my occupant burns his house down. I just see problems kind of coming out of that. So help me understand that.
Well, yeah, big problems. But the bottom line, though, is that the new buyer's insurance is going to kick in. I mean, there's dates and times when these insurance policies kick in, and if it's going to be a long, if you're going to be in there for 3 weeks or something, you do want some renter's insurance to go along with there, and you want to be named on a policy, and we're going to talk about who still pays the utilities because well, I don't own the house anymore. Why aren't the utilities in your name? All sorts of scenarios where. And I've even seen people say, well, yeah, I need to be in the house until July 1st. And well, we can close, June 1, or we can close May 1st, and that's 2 months away. Well, in situations like that, they don't want to pack up 2 months in advance, and they just want to live there. So you should have a real agreement in place that addresses all the concerns that any tenant would have. But more importantly, there's also issues of, because eviction is a civil matter, the short-term rental agreement also helps deal with the civil matters of eviction, which can be very, very important. And Utah has laws about evictions, and if it's in writing and if it's not in writing, and there's consequences and benefits to these situations. So that's why you have a rental agreement in place. And let's also talk about this too. As a real estate agent who deals in, part of your job is to help to protect the assets in writing of your clients. Think about that when making a decision about suggesting whether or not we use a short-term rental agreement. and why you should use a document to protect your asset. You know, there's all sorts of really great reasons to use it. And, you know, maybe that's the first document we should talk about, because we do review the short-term rental agreement on a regular basis for Huddle, and we'll continue to do it. But it's a good document. And I think it's one of those addendums that's used frequently and for good purpose, and you should be very familiar with it. So, yeah, a lot of pluses for using it. So, yeah. And also, I will say, you know, when things get bad for possession, and I have been in situations where, you know, angry or petulant or petty or any number of adjectives you might use for unsavory people, they're the buyer. And I've had it happen maybe 3 times in my career as a broker, where the seller, and we represent the buyer, the seller isn't fully moved out when they should be. And it's clear that, you know, it might extend into the next day, and they were supposed to be out at 1 or 2 or whatever, and they just aren't ready. And the buyer shows up and gives them attitude. And I remember distinctly watching, because I was there too. I eventually showed up because everybody was acting like the world was ending. I showed up to just see what was happening. I watched the seller walk into their house, shut all their doors and turn all their lights off, and proceeded to not answer a door or a cell phone or an email for an entire weekend out of spite. And they even called the cops, and the cops showed up and did absolutely nothing, and said, this is a civil matter. We're, you know, go get a judge's order and then we do something. So just remember that. And, you know, just a simple, just a friendly conversation could have resolved that issue so much better than anger or being mean or any of those things could have ever resolved it. So, you know, FYI. All right, going on paragraph 4. Let's see, 139. Man, we're making great progress. Paragraph 4, prorations, assessments, and other payment obligations. These can be some really important check boxes here, potentially costly if you're not paying attention. 4.1, prorations. All prorations, including, but not limited to, homeowners association dues, property taxes for the current year, rents and interest on assumed obligations, if any, shall be made as of the settlement deadline referenced in section 24D. Unless otherwise agreed to in writing by the parties, such writing could include the settlement statement. The provisions of this section 4.1 shall survive closing. Seems pretty simple, right? But special assessments, any assessment for capital improvements as approved by the homeowners association pursuant to HOA governing documents, or as assessed by a municipality or special improvement district prior to the settlement deadline, shall be paid for. And these boxes, I mean, if we represent the buyer, seller always pays for those. And maybe we learn something ahead of time where, you know, for negotiation purposes or market forces, we might pick those other boxes. But I think if we're representing a buyer writing this, you're always saying that the seller pays those special assessments. Seems like it's in our best interest. Let's see. All prorations including but not limited to association dues. Yeah, I think that seems really obvious. 4.1 is basically saying you're paying your prorated share of these expenses. And, you know, we all recognize that, you know, you're not paying a full year's worth of property taxes if you do not own the home for a full year. That type of thing. Those things seem obvious. But more importantly, I think we talk about, you know, our past huddles have talked about, this is a really good use of AI. When we talk about HOA governing documents, we had a long conversation about this the other day in regards to AI and using it to extract information from our documents. You know, there's all sorts of, when we talk about HOAs and the potential for assessments or any of those things. No, we don't have any assessments currently for our HOA. That may be a true statement, but and they conveniently leave out the fact that they've been talking about doing a special assessment for months. And so it's pretty obvious that one's coming down the line, but they conveniently forgot about that. But if you happen to have 24, 36 months, who cares? 10 years worth of the minutes from the HOA board, you can run those through AI and have a much better perspective on what's been talked about than maybe you could obtain otherwise, or by yourself, or by reviewing all those documents, which none of us ever do over the weekend, right? So that's a really good use of AI to discover those special improvements that might be, or special assessments that might be coming down the line, or even talked about. So just be aware of the, you almost don't even have to worry about it all that much if you're checking seller. But remember, if they're talking about special assessments and they haven't been assessed to the HOA yet, it doesn't matter if you picked seller, because they won't be responsible for them at closing. And that's why we want to include all those things when we're negotiating. So anybody have any questions, concerns, or experiences with 4.1 or 4.2? Great. Moving on. 4.3, fees, costs, payment obligations. This is where we agree, essentially, that everybody's sort of going to split and pay for their own costs associated with this contract. So, A, escrow fees. Unless otherwise agreed to in writing, seller and buyer shall each pay their respective fees charged by the escrow closing office for its services in the settlement closing process. The provisions of this shall survive closing. B, rental deposits, prepaid rents. I had this question the other day. This covers your investment properties. Rental deposits are not personal property. They are the property of the real estate itself, so to speak. I don't know if that's the right term, but that's how I see it. Rental deposits, including but not limited to security deposits, cleaning deposits, and prepaid rents for long-term lease or rental agreements as defined in section 6.1A, and short-term rental bookings as defined in section 1B, not expiring prior to closing, shall be paid or credited by seller to buyer at settlement. And the provisions of this section shall survive closing. So that's why those are transferred, because it seems obvious, right? You don't want to be liable for any potential deposits made by a tenant that you did not receive at closing. So you're going to want that for sure. HOA, other entity fees due upon change of ownership. Some HOAs, special improvement districts, and or other specially planned areas, under their governing documents, charge a fee that is due to such entity as a result of the transfer of title to the property from seller to buyer. Such fees are sometimes referred to as transfer fees, community enhancement fees, HOA reinvestment fees, etc., collectively referred to in this section as the change of ownership fees. Regardless of how the change of ownership fee is titled in the applicable governing documents, if a change of ownership fee is due upon the transfer of title of the property from seller to buyer, that change of ownership fee shall be paid at settlement, be paid for by, and of course, we represent the buyers, we're going to check seller, and then there's other options, and then the provision of this shall survive closing. This is becoming a big issue in our business, HOA transfer fees, change of ownership fees. We had a long, pretty lengthy conversation about this in our last sales meeting, in our in-office sales meeting, about this issue and how many of these HOAs have some type of fee, and some of them are getting exorbitant, and some of them have a actual real life effect on closing and may even prevent closing because they're asking for thousands of dollars for these transfers. I've even heard tall tale of transfer fees upwards of $30,000 for some higher end properties, not necessarily even in some of these uber luxury communities, but just nice properties and nice HOAs. They're asking for 1% in some instances, which seems outrageous, but that's happening. What do you got for us, Bob?
I was just going to say that this reinvestment fee is a real stickler, and if you could, pass on that maybe they split out this HOA from these other fees, that because a lot of times they are saying, hey, I didn't see the reinvestment fee, and then they get to the settlement date, and then all of a sudden they realize, oh, I just agreed to pay another $3,000 or something, and they're not too happy about it.
Yeah, I feel like, there's so many things, so many check boxes for a real estate agent to protect their client and, make sure everything's covered and taken care of and accounted for. The special assessment and the HOA transfer fee are becoming bigger and bigger big ticket items. And I feel like, I don't know, maybe somebody else knows if we talked about there's likely a law that has capped some of these HOA transfer fees, or there's been some attempt by our governing body, the state's governing body, to curtail some of this stuff, though all they've done is just redress the fee as something else. The bottom line is, let's think about negotiation for a minute. If the HOA transfer fees are probably going to be disclosed to us via the delivery of the seller's disclosure, why would we agree to split anything until that's been revealed to us? Right? Like, and if they do know about it and they want to disclose it to us beforehand with the proper documentation before we make the offer, which is very rare, and maybe they don't even want to do that, maybe we can talk about some other type of negotiation to split that, or account for some portion of it in one way or the other. As buyer's agents, we should never agree to pay any of this stuff, ever.
Well, Mike, I'm on a
Yeah.
very large HOA on the board of directors, and I've seen it both ways. And obviously, if I'm representing the buyer, I'm going to ask the seller to sell it. Unfortunately, there's one piece of that the seller didn't enjoy that reinvestment fee. That reinvestment fee is going to get paid out and invested in the community after the seller's left. So it's really going to be the buyer who ends up enjoying whatever that fee ends up getting invested in. So that's why I say maybe this thing should get split out a little bit, because the transfer in the community fee is typically a lot less than the HO reinvestment fee. And that, is pretty easy to put on one of the two parties. But that HOA one gets to be pretty expensive. And as these houses continue to rise in a price, for us, it's typically 0.5%. They originally wanted to start out at 1 or 2%, and we went through a period of time where it was a fixed dollar amount, and I really, honestly feel that the buyer probably is the one who's going to benefit from the reinvestment fee, and there's good reason why that person should end up paying it. But it depends on what the market's like. If you can, force the buyer to pay for it, great. Or if you can force the seller to pay for it, great. But when you're in a neutral market, the buyer's going to be the one who benefits from it.
Thank you, Bob. Yeah, I think that's the perfect flip side to the argument, is that you're buying into a lot of these communities because you like the community itself, and you like the look and the feel and the maintenance and all of the things of that community. Well, those things have to be paid for some way. And so if you don't trust the HOA board that you're moving into, well, you shouldn't move into there, right? That's a pretty simple explanation. Yeah, I think market forces will be the most important factor in determining who pays for what. But and remember, the argument of every argument that you make has almost the exact counter argument, and the example would be in Bob's example, which is, yeah, if you're reinvesting money into the community, well, I'm not around to use that reinvestment. The counter argument
I guess
would be,
a good example would be, hey, we're going to put in pickleball courts 6 months from now, and you're asking the seller to pay that. He never enjoyed the pickleball courts. The new owner coming in gets to enjoy the pickleball courts, or the swimming pool or the golf course or whatever.
Yeah, and I think the larger point of what Bob and I are talking about is what exactly, if you can identify what exactly these things are paying for, then I think you've reached the level of disclosure and communication that's necessary to figure out how to navigate these issues. Because some of these things get sticky when they're not disclosed properly, and some, if you're a listing agent and you haven't done a thorough amount of homework and gotten the right documents prior to listing this home, and you're just now discovering it, that's when things, and they can and do become problematic. But if you want to live in those communities, you got to pay for them is the bottom line. And so then it's just market forces will determine who's more motivated to pay and who's less motivated to pay. Steve says, if your seller contacts the board prior to listing for minutes, budgets, balance owed, you can save by not going through the property management companies. Also good to get the board contact information. Yeah, that's absolutely, as far as I'm concerned, if you're listing a home in an HOA of any sort, it should not go live until you have the seller's disclosure items that are mentioned on the seller's property condition disclosure. So you just shouldn't do it. There's no reason to do it. You should be able to deliver the seller's disclosures regarding the HOA and the board immediately upon upon somebody asking for it when it's live. Okay. Steve knows the answer because I knew there was something going on. I just didn't know what it was. Utah law caps reinvestment fees at 0.5% unless it's part of a larger master plan development. All right, there you go. There you go. Yeah, I don't know that it's ever really an issue if people know what they're paying for and where that money's going and how the board plans to spend it. And it just like Bob says, like, hey, that's the future of the place I'm living. If I agree to it, that's exciting. I'm happy to pay for the things in the places that I'm going to live. Problem solved, right? All right. Anybody have anything else on the special assessment? And that was 4.2, 4.3 through C. Also, 4.3D. These ones are kind of easy. Utility services. Buyer agrees to be responsible for all utilities and other services provided to the property after settlement. The deadline, the provisions of the section shall survive closing, and everybody's favorite subparagraph 4.3E, real estate brokerage compensation. I mean, I think all of us know this all by heart by now, but we're going to talk about it anyway because we said we would. Seller and buyer agree that seller shall contribute a large amount of the purchase price to buyer's brokerage or this specific dollar amount to buyer's brokerage if applicable. Seller's compensation contribution. If no amount is entered, then seller has not agreed to compensate buyer's brokerage in the REPC. This payment shall be made in addition to any other compensation agreed to by the seller's brokerage to buyer's brokerage, if applicable. Buyer agrees that seller's compensation contribution combined with any other payment from seller's brokerage, if applicable, to buyer's brokerage shall not exceed the amount agreed to by buyer and buyer's brokerage in their written buyer-broker agreement. The provisions of the section shall survive closing. And this will be the last, no, we're going to talk about F2 before we get out of here. For the uninitiated, a lot of that language really just comes from the settlement, our very large settlement that the NAR agreed to. And some of it is really slightly bizarre and hasn't had any effect on our industry whatsoever. And if you'll recall, that last sentence, the shall not exceed the amount agreed to between buyer and buyer's brokerage in their written buyer broker agreement. If you'll recall, that was a major deal, and it seems like, of course, like you agreed to what your compensation will be. Why should you get paid more? Seems very reasonable. And many attempts were made by sellers and listing agents to enforce that. Seems to have fallen by the wayside. And I think the NAR settlement actually proved to boost buyer's agent commissions as opposed to anything else they might have been expecting. Anybody have any questions on E? I mean, that's, I think I've even seen a tattoo of that particular subparagraph on somebody before. So anyway, pretty interesting. Let's cover F and then we'll be done. 4.3F, sales proceeds withholding. buyer and seller authorize and direct the escrow closing office to withhold from seller's proceeds at closing sufficient funds to pay off seller's behalf of all mortgages, trust deed, judgment, mechanic liens, tax liens, real estate brokerage compensation, and warrants. The provision of this section 4.3 shall survive closing. That is where all parties are authorizing the escrow title company to follow the contract, and that's what they agree. Those amounts written in the contract they can actually sort of enforce, right? So anyway, there you have it. All right, it is 1:58. We're going to go ahead and wrap up. We actually made pretty good progress, considering we only covered one solid paragraph last time. So we will start on agency next time. Does anybody have anything they'd like to talk about, any contribution they'd like to add before we send you all on your way to a wonderful, exciting weekend? Anyone? All right. Oh, someone was going to say something. What were we going to say?
Mike, who you voting for, or who you betting on for Sunday?
I am not a Patriots fan. So if there's any team other than the Patriots, I might, have waffle one way or the other, but definitely betting against them as opposed to for Seattle. So, they're not on like my hated list, but it would bring me some joy to see them lose. Not a lot of joy, but a little bit. So, yeah. How about you?
I'm pulling for Seattle.
Okay. All right. There you have it, all. Place your bets in the states where it's legal. All right. Have a good day. Have a good one, y'all. We'll catch you later.